Subrogation. This is the first time that we've actually had a guest presenter with us. As you know, we've presented a number of webinars over the months that have generated some rather high attendance, and we are in good stead this morning with over 300 people registered for attendance. So clearly, even though we're going to focus in this webinar on just one state, this webinar is going to be useful for practical basics of PIP and MedPay subrogation in a number of states. The state of Washington is somewhat typical in a number of aspects. It employs the made whole doctrine and the common fund doctrine, and has PIP and MedPay law, which forms the basis for a lot of what we're going to be talking about. Eric, welcome.
Thank you. Glad to be here.
Eric is our local counsel down in Washington and handles a good deal of our PIP and MedPay subrogation down there. Before we get started, I wanted to remind you that you can go to our website, and I'm going to take you there right now. You can go to our website. Jamie, can you see the website okay? This is the home page of the website, and I always point out to people attending the webinar that you can scroll down on the home page till you get past the published books and get to the area marked Insurance Resources right here. And below Insurance Resources, as you can see, we have a number of insurance resources, subrogation resources that are of benefit to all of our clients and friends. They're free on our website. The number one topic that's listed there, dog bite laws in all 50 states, was just added today, by the way. But if you scroll down, you can scroll down and actually see that we have a chart that may be of use to you. If you handle PIP and MedPay subrogation, right here is PIP and MedPay subrogation, and you can click on that, and up comes a chart that details a summary of PIP and MedPay subrogation in all 50 states. Part of the problem with doing a chart and doing a seminar like this is it's often hard to anticipate every possible scenario that you'll be running across as you subrogate PIP and MedPay in any of the 50 states. We'll talk in some detail today about Washington, and when you listen to Eric and myself go through some of these scenarios, you'll realize why plaintiffs' attorneys have a field day attempting to minimize or threaten you to eliminate your lien, because the law is, in many cases, is not well settled. But we'll talk about the things that are settled today in Washington, and hopefully we'll give you some ideas on how to more effectively subrogate for PIP and MedPay in the state of Washington. So let's get started. No-fault PIP and MedPay in the state of Washington. A little bit of background. No-fault, I'm not a fan of no-fault, but from about 1971 to 1976, in an effort to hold down the cost of automobile insurance, some 15 or 16 different states enacted no-fault automobile laws. And these laws feature two key components, two ingredients. Number one, the mandatory purchase of first-party no-fault coverage for med benefits and loss of income for drivers and passengers. These are usually referred to as PIP benefits, but not always. The second component is a limited third-party tort liability. The negligent drivers benefit from a limited right on the part of the injured party to sue the negligent driver. During this time period, 3 other states enacted similar no-fault laws, but they didn't limit tort liability, so every state is different. And when you're subrogating PIP and MedPay, you're going to find that every state has its own twists and turns. We're going to cover pretty thoroughly Washington today, but as I said, this can be a template and a good background for you if you're subrogating PIP and MedPay in any of the 50 states. Now, no-fault has been given mixed reviews, a mixed report card over the last 30 years. Since 1976, no state has adopted no-fault, but several states have repealed their no-fault laws, an indication that it really isn't functioning to reduce litigation costs and payment for non-economic damages as it was intended. Opponents of no-fault argue that no-fault unfairly benefits negligent drivers. They point to statistics which show that rather than decreasing insurance premiums, it actually causes premiums to increase. Advocates claim the opposite, and each camp has their own facts and figures that they can use to substantiate their claims. When we talk about PIP benefits, we want to be sure that usually PIP benefits are associated with no-fault automobile insurance. MedPay benefits usually are not. And although subrogation of these two types of automobile insurance benefits has become big business, there is still a significant misunderstanding and confusion as to these two types of benefits and when and under what circumstances they can be subrogated. So just to be clear, MedPay benefits pay for medical expenses of an insured and his or her passengers. Automobile laws vary from state to state, but this coverage usually includes accidents which occur while an insured is driving someone else's vehicle with permission, or can also include injuries to the insured or his family members while they are pedestrians and, of course, while they're operating their own vehicle. MedPay will pay no matter who causes the accident, although if someone else is at fault, the auto insurance company usually has a right of subrogation. Again, go to the chart I pointed out on the website, and it will indicate in which states you can and can't subrogate for MedPay. And in fact, some states don't have MedPay. They only have PIP, and in other states they only have PIP and not MedPay. PIP benefits provide coverage. They provide benefits for medical expenses and lost wages incurred by the insured and his or her passengers involved in an accident. And as you can see, they're required in a number of states that I've listed there. So there is a big difference between PIP and MedPay, and keep in mind that some states offer one but do not offer the other. Now, getting to Washington MedPay subrogation, I'm going to turn you over to Eric Vershbo, who is a little more familiar with some of the details out there than I am, and he's going to give you an overview of Washington MedPay subrogation. Eric?
Thank you, Gary. Now, Washington MedPay and PIP reimbursement is governed largely by the Mahler precedent. Prior to the Mahler case, there was widespread confusion among attorneys in Washington about how PIP should be reimbursed, if it can be reimbursed under Washington law. And all of that sentiment and need for clarity in the law coalesced in the Mahler opinion when a number of amicus briefs were submitted, and they did finally get clarity. And there were other cases that came in the immediate aftermath of Mahler that further clarified or tried to clarify the circumstances in which an insurer's subrogation right to its PIP or MedPay would be available. And Safeco versus Woodley is one of those cases, because this case concerned the UIM context. What happened here was Safeco had a pretty substantial PIP lien out there in excess of $56,000. The insured in the underlying matter settled with the liability carrier for the policy limits. And what Safeco did there was they waived their lien in the context of that underlying claim. And that was somewhat at issue in the case about whether that waiver meant just a complete waiver of any entitlement to reimbursement or whether it was just in the context of that underlying claim. Because then when Woodley attempted to assert a UIM claim against Safeco above and beyond the liability limits, Safeco tried there to use its PIP lien as an offset against that UIM recovery. A number of arguments were made, including that Safeco had no right under the law to subrogate for PIP, that in waiving their lien against the liability settlement, that they, against the liability limits rather, that they no longer had the ability to use a lien as an offset. And then there were a number of questions about, well, what happens to attorney's fees and how does that get reimbursed? The result was that the court ruled that Safeco did, in fact, have a viable subrogation claim for its PIP reimbursement. And this really is the constant in Washington since Mahler, is there is a recognition that carriers, PIP carriers, do have subrogation rights in Washington, and sometimes there's some confusion about that, given the made-whole doctrine and some of what's said by personal injury lawyers. But there is a right. There is a right to PIP reimbursement and subrogation, and this was, again, affirmed in Woodley. And the court did say that Safeco could use its lien, or could enforce its lien as an offset against the UIM recovery. So this was a defeat then for the plaintiff's counsel there. And in addition, they said that even if there had been a waiver in the context of the liability case, that waiver did not preclude them from using this offset in the UIM context. And they actually got in some of the correspondence that was exchanged by the attorneys, and they figured that this was not a knowing and voluntary waiver. Maybe in other circumstances, if there's more of a complete waiver, they might find a waiver, but here there wasn't a waiver. And because Safeco does have an equitable right to subrogate, and because there's that recognized right, they did allow them to apply their offset against the UIM recovery. The Court of Appeals in Woodley left it open about the attorney's fee issue, whether the attorney could recover pro rata fees against the UIM claim. That was cleared up really on review by the Supreme Court and later in Ham, where they did say that, yes, attorney's fees were recoverable in prosecution not only of the underlying claim against the liability carrier, but also in the UIM claim, that Safeco would be responsible for those pro rata fees in both contexts. The Supreme Court in Woodley affirmed that with respect to the UIM setting, and then Ham later came along and reaffirmed that, saying that the insurer must also pay the pro rata legal expenses incurred in arbitrating the UIM claim. So that they have to pay pro rata in the underlying claim against the liability carrier for the limits, even though Safeco didn't really have any interest in there. And then later they also have to pay pro rata expenses, legal expenses in the UIM claim, where essentially what they're doing is paying the plaintiff's attorney pro rata expenses to litigate the claim against itself. But that's how they came down. And then we get into the Mahler case. And again, as I've said, this was the seminal case. Anybody who's being introduced to subrogation law in Washington, this is the first case that they have to read, because this case laid it all out. It was highly anticipated, and it was from the Washington Supreme Court, issued after a lot of consideration of basically everybody's varying points of view. And Mahler, what they did there was, once and for all, they did decide that, yes, subrogation is recognized in Washington. Carriers do have a right to subrogate for PIP, subject to the made-whole doctrine. And that's the big issue. I mean, throughout the Mahler opinion, again and again, they say that made-whole is the policy of Washington. So beyond made-whole, and they're going to adhere to made-whole as sort of the primary, foremost consideration in evaluating PIP subrogation. But beyond made-whole, then PIP reimbursement is available. There's always the question of, you know, can you rewrite your policies to get around that? You certainly cannot with regard to the made-whole doctrine. And then with regard to the common fund doctrine, or this issue of attorney's fees, again, there's a lot of language in Mahler saying that does reaffirm the common fund doctrine, and that the carrier is responsible for pro rata fees. And again, the common fund doctrine would apply there as well. So what we have there are these two very clear holdings in Mahler. I mean, one being that, yes, there is the right to PIP reimbursement, and the subrogation rights do exist in Washington. And second, there's the absolute fidelity to the made-whole rule. And then there's the explanation of the common fund doctrine and how that applies as far as the pro rata payments of attorney's fees on behalf of the PIP carrier to the personal injury lawyer.
All right, so we've now established that there are PIP and MedPay subrogation rights in Washington. The Mahler case is the Bible on the subject. But of course, Mahler leaves some questions unanswered. Eric also mentioned that the made whole doctrine is sort of the umbrella over which, under which all of PIP and MedPay subrogation is operating, and he also mentioned the evil words plaintiff's attorneys. The plaintiff's attorneys representing your insured in their bodily injury claims will most assuredly pull out the made whole throwdown doctrine and claim in almost every case that they're not made whole. We're going to go through some of this and the origin of the made whole doctrine in Washington and how to defeat some of these spurious claims where they are spurious, and then also we're going to get into some of the various scenarios in which the made whole doctrine will apply. Made whole in Washington starts with the Thiringer versus American Motorist Company case, Washington Supreme Court case way back in 1978. This is a case that announces, for Washington at least, its public policy in favor of full compensation for injured persons. It announces the rule basically that no insurance company has a right of reimbursement unless the plaintiff has been fully compensated for his or her injuries. And you're going to hear Eric and I use the terms subrogation and reimbursement almost interchangeably, but there is a distinction. Subrogation refers to the stepping into the shoes of your insured in order to prosecute a legal claim that he or she or it may have against some third-party tortfeasor. So if you are going to pick up the banner of subrogation, you're literally going to be pursuing the third party. Reimbursement, on the other hand, is more generally referred to when you have an insured who hires a lawyer, they file suit, they make a recovery, a settlement, a judgment, whatever, and that money then has to be dispersed. And we step in and claim either by intervention or simply providing them notice, but we claim that we have a right of reimbursement. So the two are actually distinguishable. But in Thiringer, Henry Thiringer was involved in an automobile accident. He had PIP, personal injury protection coverage, which obligated American Motorist Insurance to pay certain medical, hospital, and income continuation benefits. He reported the accident to American, and employees of American told him that because the other driver had insurance and was at fault for causing the accident, that PIP coverage was not available to him and that he should pursue the other driver. Well, Mr. Thiringer went out and did what most insureds do. He hired counsel. And together they accepted the other driver's policy limits of $15,000. It was established in the record that the other driver had no other reachable assets. He was judgment-proof, in other words. Mr. Thiringer fully released the other driver, and after settling and believing that his damages exceeded the $15,000 settlement, Mr. Thiringer demanded that American pay PIP benefits. American refused, and we have this case as the result. The Supreme Court ultimately decided the rights of the parties, and the Supreme Court rejected the insurer's argument. They rejected American Motorist's argument that it had been prejudiced by the settlement because they were trying not to pay PIP benefits. And they did so on 4 grounds. First of all, they said the settlement exhausted first of all, they rejected the insurer's arguments on 4 grounds. The insurer claimed that the settlement had exhausted the tortfeasor's present and prospective assets, so the insurer had lost nothing by the signing of the general release. The court said the insurer had not actually paid PIP benefits yet, so it was stopped to contend that its right of subrogation was affected. So essentially it held that there were no subrogation rights which were in existence because no benefits had been paid. It also mentioned that since the PIP interest may be small compared to the total damages, it would be unfair to require the insured to surrender his right to pursue a third-party tortfeasor in court in exchange for getting PIP benefits. So in other words, they said it would be unfair to force the insured to choose only one remedy, PIP or a third-party recovery. And lastly, the court said it was unrealistic to expect that the tortfeasor would accept only a partial release to settle his claim for policy limits. So under these facts, and with this holding, the Thiringer court addressed the issue of allocation of settlement proceeds between an injured person and the insurer. And it announced in Washington for the first time what is commonly referred to as the full compensation or made whole rule. We've all heard of it. It's applied differently in every state. There are different rules regarding when you're made whole, what you have to do to prove you're made whole, who has the burden of proving you're made whole. We'll go through those things in Washington. But essentially, Thiringer stands for the proposition that an insurer is not entitled to recover until its insured is fully compensated and fully restored to his or her pre-accident condition. In fact, I'll quote from Thiringer. It said, quote, "The general rule is that while an insurer is entitled to be reimbursed to the extent that its insured recovers payment for the same loss from a tortfeasor responsible for the damage, it, the insurer, can recover only the excess which the insured has received from the wrongdoer remaining after the insured is fully compensated for his loss." We're going to be going through some examples of this in just a moment to make this a little clearer. But the court went on to say that this rule embodies a policy deemed socially desirable in this state, in that it fosters the adequate indemnification of innocent automobile accident victims. So, because this holding is based on public policy, an insurance company is not allowed, as it is in some states, to simply redraft their policies and contract around the made-whole doctrine. That's not allowed in Washington. Now, the made-whole doctrine, which is also known as full compensation, means that the actual losses sustained by the insured regardless of comparative fault. And the court said, we find nothing in the language of the policy to indicate that the parties agreed that a different principle would apply to this contract. Now, that's in the Thiringer case. If it did, they said it would be unfair. So overriding, as I've indicated, the made-whole doctrine by contract is not going to be allowed. But the made-whole formula is something that we as subrogation professionals are going to be concerned with. How does the made-whole formula, which is different in all 50 states, work in the state of Washington? Let's look at a couple examples. Example one involves a situation where the PIP carrier pays $10,000 in PIP benefits. Let's say there's also a health insurance company out there that pays an additional $5,000 over that $10,000, and they may have subrogation rights too. We'll get into that in a moment. The liability carrier pays $25,000 policy limits. Let's assume that the third party is judgment proof, so that's all the money there is. And a UIM arbitration determines that the total damages are at $40,000. Now, I use arbitration, no pun intended, arbitrarily, as an arbiter, no pun intended again, of what the damages are, but this could be determined by a court as well. I'm just using an arbitration here because it's simple and because it gives us a value of the case. We'll talk later about what happens when there is no determination by ARB, by a judge, as to what the total damages are. Lastly, the UIM carrier pays $15,000 because the $40,000 in damages sustained by the insured isn't paid for by the $25,000 policy limit, so the UIM carrier has to kick in $15,000. So let's see how this shakes out. In this scenario, the total recovery from all sources is $55,000. Can you see that? First of all, there's $25,000 from the liability policy, there's $10,000 from PIP, and there's $5,000 from the health insurer. The UIM, it kicks in an additional $15,000, so the total is $55,000. The total damages are less than the total recovery. They're only $40,000. Therefore, in this scenario, $15,000 is subject to potential reimbursement claims, and the PIP carrier and the health insurance company should be able to, assuming the health plan has proper language, should be able to recover its subrogation interests. Let's look at another example. In this example, the PIP carrier pays $10,000. The health insurance company pays $5,000. The liability third-party carrier pays $25,000 in policy limits. Again, the third party is judgment-proof. Beyond that, UIM arbitration determines that total damages are now $75,000, and as a result, the UIM carrier pays $25,000. In this scenario, the total recovery from all sources is $65,000. Total damages determined at $75,000. Because the total damages exceed the sum of all recoveries, no funds are subject to the PIP subrogation rights. Again, here we have damages in excess of the total recovery. Notice that Eric mentioned, Eric mentioned subrogating against UIM benefits. You can see that in action here. the UIM benefits are actually calculated into the total recovery, and our subrogation rights are played off of that. But under example 2 here, because the damages exceed the total recovery, PIP doesn't get repaid, and probably the health insurance company doesn't get repaid either. So let's move on to another example. In this example, PIP pays $10,000. The health insurance company pays $5,000. The liability company pays its $25,000 policy limits. The UIM arbitrator or arbitrators determine that the total damages are $60,000, so the UIM carrier kicks in $25,000. The result? The total recovery from all sources is now $65,000. $25,000 UIM, $25,000 liability, $10,000 PIP, and $5,000 from health insurance. My math adds up right. But the total damages are $60,000. So we have a total recovery that is only slightly in excess of the total damages. We have a $5,000 surplus. This $5,000 surplus is subject to PIP subrogation rights. Now, we're not going to get into yet how differing subrogation rights between the PIP carrier and the health insurance carrier are going to be resolved. We'll talk about that briefly in a minute, but you can see now that the PIP carrier is subject only to the rights to recover $5,000 under this example. Thiringer, while it is the clearly establishes the made-whole doctrine and its application in Washington, also presents some other interesting problems and issues. Now, in a perfect world, there's a legal answer to everything. And you should be able to call up your subrogation counsel and say, who's got the burden of proof? You know, what happens if there's comparative fault? And your lawyer should say, why, that's the Smith versus Jones case, and clearly this is the answer. I wish that were the case, but unfortunately, it's not. There are still some questions that remain unanswered. But let's talk about some of the issues. Number one, who determines the value of the third-party case? The Washington Court of Appeals has established in a case way back in 1985 that an injured party cannot just subjectively value his or her own injuries and thereby bind his insurer, because there are some states where even an assessment by the plaintiff is some evidence of the value of a case. And of course, no insured is ever made whole, and no insured is ever damaged less than $1 million. There's always some huge figure that they attach to their particular case in terms of their total damages. But it's important to know that an objective valuation of the party's injuries by a trier of fact, a jury, or an arbitrator is going to be needed in order to do the calculations we saw in the last example. So, Eric, I don't know if you have any examples or war stories, but isn't it pretty common that a plaintiff's attorney will simply call you up and say, well, in my opinion, our damages are, $395,000, never mind the fact that there's only $5,000 in medical?
Oh, yeah, absolutely. I mean, this is really the central issue that we encounter in PIP reimbursement is valuation of the claim. Because as you say, the plaintiff's attorneys are always going to overvalue the amount of the claim, and certainly what you want to do as the PIP carrier is not just take their word for it, but you want to, one, do an independent evaluation of what you think the value might be, and then if you think it's worthwhile, you want to litigate that and have an arbitration or even a trial just on that issue. And that's really what the guts of PIP subrogation is about in Washington, is just figuring out what the value of the claim is, getting to that amount, and then making this determination on whether, in fact, an insured is made whole by a limits offer. Typically what it does amount to, especially when you have minimal limits, what it comes down to is the UIM proceeding, and that's where you get arbitrators who are very experienced at just deciding what the value of the claim is and then weighing that against the available UIM money. That's why, as in Woodley, oftentimes it's the smartest course for a PIP insurer is just to not involve themselves in a suit with respect to the liability limits and not have that fight there, where you could be subject to bad faith issues if you're really out of line in raising the issue in that context, but instead to raise it in the UIM context and try to assert an offset there. And that's typically when you do, in fact, see the matter litigated and decided, where a UIM arbitrator or an arbitration panel will come forth and say, as they did in Woodley, this is the value of the claim.
It's interesting, but in every state we subrogate in, and we obviously we have a national practice and we have local counsel, not as good as Eric, but we have local counsel in all 50 states, 265 sets of them, so we are where you need us. But all of these lawyers will tell you the same thing, and that is that in every state we attempt to subrogate PIP and MedPay, one of the biggest issues that comes up is what is the value of the third-party case? There are states like Wisconsin which require something called a Rimes hearing. That's basically a court-adjudicated determination of what the value of the case is in order to figure out is or is not the insured made whole. What's interesting is that in most states, this procedure is not very well documented. It's not very well. There's no three-ring binder with complete procedures on how to handle Rimes hearings in all 50 states, even in Washington. So the minute you start to buck back, you arch your back a little bit and resist the plaintiff's attorney's efforts to destroy your subrogation interest, he realizes he may have a problem. He does not want to, any more than you do, have some kind of judicial determination of the value of the third party. He wants to take his money and run. And quite often his fee is the same, whether he pays some of his money back to you or pays it all to his client. Now, it's sad, but a lot of lawyers will cave in, not even advise their client on all their rights under Thiringer and all of the things they could be doing to battle you, who will be obstinately sticking to your guns and claiming your subrogation rights. So the value of the third-party case is a big issue. But what if the insured settles his BI case for less than policy limits? The Washington Supreme Court in 2001 in Liberty Mutual versus Tripp specifically came out and held that there is no presumption of full compensation or prejudice to the insurer simply because the plaintiff settles for less than policy limits. The issue of full compensation is still a factual question that may be determined by the trial. Insurance companies are well positioned, however, to argue that, especially in cases where there's very little contrib and the case is settled within policy limits, that means any case settled with a large corporation with unlimited resources virtually, that there must be a reason for settling for the amount they did. And that reason we're going to argue is that that is the value of the case. That's what they're willing to risk. Trial attorneys will tell you, well, but there's risks involved with trial. That's why we had to discount our case. But all of those get into some very speculative and subjective determinations of what the value of a case is. So there are some states like Georgia where you are presumed, there's case law indicating you are presumed to have been made whole if you settle for less than policy limits. Otherwise, if you're not happy with your settlement, go try your case. These are good arguments to make when you're on the phone with the plaintiff's attorney, but just know there is some law out there that says they're not automatically presumed to have been made whole, to not be made whole, simply because they settled their case for less than third-party limits. What if the insured is made whole, but only by a little? Well, we talked about that in some of our examples by implication. And you are only subrogated to the amounts that are in excess of the recovery that was made in the third-party case and any other collateral sources. There may be competing subrogation rights, but those other recoveries get factored into the total recovery, and you are only allowed to recover what is in excess of that amount. Are the insured's attorney's fees figured into the recovery? Well, the Washington Court of Appeals has looked at this narrow question and asked whether or not the fact that the plaintiff has to pay attorney's fees to obtain the settlement means that the plaintiff is not fully compensated under Thiringer. And this is where we get into a lot of problems in other states, because there are some states that say, no, you don't calculate attorney's fees into your total recovery. Well, that's really rather bizarre, because if that's the case, unless plaintiffs are out there recovering a lot more than their damages, they're never going to be made whole. Luckily, Washington is a good state, and the case of Peterson versus Safeco Insurance Company of Illinois, decided in 1999, stated the following, quote, denying a first-party carrier its right of reimbursement until its insured has been fully compensated, including his or her attorney's fees, would represent a shift in legal policy of this state, which is best left to the Supreme Court. So what they did is they didn't really answer that question, but they did say that the question of whether an insured has been fully compensated does not arise until assets, or at least those assets readily accessible through a liability policy, have been exhausted, has been overruled. In other words, the attorney's fees are to be included in. You don't subtract them and then the insured says, well, I'm not made whole. Look, I had to pay my attorney 40%. It's not going to fly. So don't let that argument deter you. Next, we talked about what if the insurer is made whole by only a little. It looks like I jumped over one. Next, what if there are more than one subrogated party? Eric, I think we're getting into areas here where there are no bright line rules. There's no clear answers as to how allocations are to be apportioned when you have, as in our previous examples, a PIP carrier with a $10,000 payment and, say, a health carrier with a $5,000 payment. Do you agree?
Yeah, I think that's right. And as you mentioned earlier, I mean, a lot of this is resolved in the negotiation process. Everybody really has an interest in settling the case. Certainly when you're at the point where a plaintiff's attorney realizes that their client is being made whole and there is other money available that could be paid to subrogating entities, it's certainly in his interest to make sure that everybody's happy, and when releases are signed, everybody's good on the release and there aren't going to be any extenuating issues that are going to come back after him later. So typically what will happen is the plaintiff's attorney will take it upon himself to make everybody happy and explain the scenario to the PIP carrier about the money that is in fact out there. It's not enough maybe to reimburse the entire lien, but there might be some money available for the PIP carrier, and he'll explain about the other liens as well. And more often than not, if he's able to substantiate that, yes, these other liens are out there, everyone will work together to reduce their liens and perhaps just a straight prorated formula so that everybody does get reimbursed. Other than that, there aren't really any bright line rules establishing priority of one subrogating entity over the other. So really it is in everybody's interest just to try to resolve it informally on that basis, rather than just have various lien holders trying to fight it out or to establish reasoning why they might be more entitled to a greater share of their recovery than another lien holder.
So this is a good example of how, when there are no clear answers, this is fertile ground, fertile territory for plaintiffs' attorneys to try and creatively defeat your rights to reimbursement or subrogation. They can come up with all sorts of allocation formulas. This happens in workers' comp quite often. But when it comes to PIP and MedPay, some possible allocation schemes can be you take the $10,000 paid by the PIP carrier over the total damages determined by the arbitrator or judge, and you get a figure of 25%. You then take 25% off of the attorney's fees that are owed, because as you can see here, we're going to talk about common fund doctrine and attorney's fees. A subrogated insurer can be held responsible for a pro rata share of the insured's attorney's fees. And a good formula for that, again, pro rata, is to take the total amount paid by the PIP carrier over the full value of the case, $10,000 over $40,000 in the case of our previous examples, and you get a figure of 25%. So 25% of the attorney's fees, $3,750. In the case of attorney's fees, $15,000 will come off of the PIP carrier's $10,000 subrogation amount, and the PIP carrier will net $6,250. Same thing for the health carrier. When there is limited funds available, let's say there's only $5,000 available for subrogation after the insured is made whole, and yet you have both a 10,000 PIP claim and a 5,000 health insurance claim, or comp, I mean, what have you. You have a situation where the parties had, as Eric says, best get together and hammer out a compromise. Pro rata is usually a fair assessment, but there is no case out there that you can read and point to the other side and say, this is the formula we have to follow. Thiringer applies in some situations, arguably, and may not apply in others. Plaintiffs' attorneys will argue, and perhaps they're right, that there are some scenarios where Thiringer's full compensation rule would not apply. It doesn't apply in any case where the injured person obtains a double recovery. And in Washington, the entire premise behind Thiringer is to prevent a double recovery. That's sort of the gospel. As important as making the insured whole, it's just as important in Washington, and this is important to remember, that the injured party not receive a double recovery for any elements of its damages. Other examples where the Thiringer rule may not apply, where an injured party knowingly prejudices the insured's right of subrogation, could be another possible situation. And perhaps any scenario where the insured cannot meet its burden of proof that the insured was fully compensated. How do we meet that burden of proof? Because we do have the burden of proof of proving that the insured has been made whole. It's not that the plaintiff's attorney has to prove he hasn't. We simply have to prove he has. But we can overcome that burden by offering some evidence that the damages are not quite as high as the plaintiff's attorney is claiming they are, and then they will probably have to rebut that. So meeting the burden of proof may not be all that difficult. How do you do it? You can submit medical records. One of the easy ways is to, and most judges are prior lawyers with litigation experience either on the plaintiff's or defense side, and will relate to this. But you could tell them, look, a good rule of thumb is to take your special damages, your medical expenses, reasonable and necessary, as well as your lost wages, add those up and triple them. And that's generally a good rule of thumb of what a average personal injury case is worth. So if you have $15,000 in medical expenses and lost wages, your case can reasonably be somewhere in the area of $45,000 in terms of its value. That's a good rule of thumb, and most judges will look at that and nod and go, yeah, you know what, I think that's right. So plaintiff's attorney, how can you be claiming your case is worth $175 when your specials are only $15,000? If more money is involved, you can actually go a little further. You can get an affidavit from an attorney who's practiced in that state as to the value of the case. You can actually put on evidence in terms of what the future medicals are. A good source of information is to go to the defense counsel. They won't always cooperate with you, but if you can get, or you've been involved in the case, if you've had subrogation counsel, and this is another reason for having subrogation counsel, you can actually get some of the discovery submitted by the defendants, and some of it may provide you with ample opportunity to ding away at the plaintiff's attorney's alleged value of the case. This could be pre-existing conditions. It could be IMEs indicating that the plaintiff is malingering. It could be a number of things that might weigh on the judge's or arbitrator's mind in helping to keep down the value of the case. So Thiringer does apply when there is contributory negligence. Plaintiff's attorneys will try and argue, Eric, and I don't know what your thoughts are on this, but if they're going to argue, look, the tortfeasor was 80% at fault, the insured was 20% at fault, therefore I want to reduce your PIP subrogation payment by 20%. To my knowledge, there's no established law that says the judge has to go along with that, is there?
Yeah, I think that's right. I mean, the big question, certainly with respect to made whole, is whether the comparative analysis has implications on made whole. For example, if you find that the insured was 50% at fault, particularly in a pure comparative negligence state like Washington, you would naturally assume, well, then his damages would be reduced by 50%. And that certainly might be true with respect to the liability carrier and in that analysis. But as far as the made whole analysis and with respect to PIP reimbursement, the law actually is that even if he was 50% at fault and would be entitled to 50% of damages in the liability context, he is still not made whole for the purposes of Thiringer and the Washington made whole doctrine. So even apart from the comparative analysis, the Washington law says, as a point of fact, he's not made whole, meaning that he hasn't been fully compensated for his injuries, regardless of how at fault he was for the underlying collision. So the plaintiff's attorney can still throw Thiringer and the made whole doctrine at you as a PIP carrier seeking reimbursement, saying that he wasn't made whole, irrespective of the comparative assessment.
So, some of these questions, again, as we go through these other Thiringer issues, are not going to be fully established. We've talked a lot in our previous examples of PIP subrogation about judgments or arbitration decisions which precisely determine the total damages to an insured. But what if there's a settlement rather than a judgment or an arbitration decision? It's just important to realize that settlements, at least according to the plaintiff's attorneys, almost never reflect the total damages. That they'll claim that they're less than total damages because the settlement includes such things as, issues of proof, costs of continued litigation, comparative fault, pre-existing conditions, witnesses who are, not cooperative, and simply the desire of the plaintiff to move on with his life. We shouldn't make the presumption that, again, simply because they settle for less than policy limits, they're not made whole. But it's in these settlement cases where we're going to have to be creative and simply not fall for the plaintiff's attorney's ruses. As Eric mentioned, the plaintiff's attorney's logic is going to be, at least in the case of comparative fault, hey, if the jury had found the plaintiff 100% at fault, there'd be no money for anybody in this case. Therefore, if the jury finds the plaintiff responsible for 50% fault, it's only equitable that the subrogated carrier should receive only 50% of their subrogation interest. As Eric pointed out, that's simply not the case. The recovery is what the recovery is, and the only issue is whether or not he's made whole in light of that recovery. But because we don't have rock-solid, bright-line answers to a lot of questions, it is probably best that we go into some of the tips that we have for handling Washington subrogation, especially in some of these areas where we simply can't point to a case or a statute and say, aha, you've got to comply. So, Eric, what are some good tips you might have in terms of Washington PIP and MedPay subrogation?
Well, Gary, really the guiding thinking here has to be that while the made whole rule really does have primacy in Washington, we can't forget that a PIP carrier does have reimbursement rights and subrogation rights, and that's been reaffirmed again and again. So, for example, one thing that a plaintiff's attorney can't do is just go ahead and take the policy limits of a liability carrier and then have his client sign releases waiving claims against that liability carrier as well as that liability carrier's insured without the consent of the PIP carrier. Because the PIP carrier still does have a valid claim out there, even if there are minimal liability limits, and it seems like a foregone conclusion that at least the insured's damages total that amount, if not far more. The Elovich versus Nationwide case reaffirms that it is possible still for an insured to prejudice the rights of the insurer to that insurer's viable subrogation interest. For example, in that setting, while the liability limits are minimal and those are all being paid, and while there might even be a UIM claim out there, there's still an adverse underinsured motorist. And that's something a lot of people forget, is that when the liability limits are paid, and when the tortfeasor does in fact pay everything, that he's covered for through his insurance coverage, there are still claims against that adverse driver. And a lot of times these drivers have a lot of assets independent of the insurance coverage, and those assets are certainly worth pursuing. But the plaintiff's attorney, in the rush to settle the liability case, will have his client go ahead and sign releases against not only the liability insurer, but against that adverse insured personally as well. And what that's doing is that's prejudicing your rights to recovery, and he frankly can't do that. So if something like that does happen without the carrier's consent, it could have implications on the UIM claim, for example. I mean, that might be something that you could raise in the context of the UIM claim, that the carrier was prejudiced with respect to seeking reimbursement from the adverse underinsured motorist, and that could have implications on the UIM claim. So that's something to remember. The plaintiff's attorney can't just run roughshod over you. He needs to be consulting with you and conferring with you at every stage of the process and having you understand exactly what's being released, when releases are being signed, and having you on board with that. Because there are a number of cases, as I've said, where the adverse motorist does still have assets above and beyond his coverage, and those cases are worth pursuing for a subrogating insurer. And remember that Mahler made clear that it's possible for a carrier to also bring an independent action, an independent subrogation action, for example, where the insurer just elects not to bring a suit in its own name for various reasons, which certainly has been known to happen. Then we have a regular subrogation scenario where an insurer can bring its claim in the name of the insured or via an intercompany arbitration scenario. If the carrier does elect to bring an action in the name of the insured, it's certainly smart to keep the insured apprised of the entire process and give them every opportunity to join in the case. But that's a case where the insurer can, in effect, control the litigation, hire its own counsel, and ensure that its PIP interests are protected to the extent possible. So if you're running up against a statute of limitations and the insured hasn't brought a claim and you're wondering if they're going to, you're not even clear whether they have brought an attorney, it's certainly smart to go ahead and give them a call and just say, are you bringing a claim or are you not bringing a claim? If they say they're not bringing it for whatever reason, you could go ahead and bring it. If you can't get in touch with your insured and you're running up against a statute as well, it's certainly advisable, if you're not aware that a suit has been filed, to go ahead and bring a suit in the name either of the insured or in the name of the carrier, and doing it that way. If the insured materializes later, you can go ahead and include his interest in the suit if that's what he wants to, if you're permitted to amend. But at the very least, the carrier's interests are protected there. So it's smart not to just sit back and wait for a personal injury attorney to materialize and make themselves known to you and then start trying to push you around, but to stay proactive, to be aware of when an insured has not yet brought a claim, to keep in mind when the statute of limitations is pending, and to know that you can certainly go ahead and file a lawsuit. If you do file a lawsuit and then you become aware that, well, the insured had retained an attorney and they had filed a separate lawsuit before the statute had run, worst case scenario is you just dismiss your case. So there's really no harm in doing that.
Statute of limitations for negligence actions in Washington, 3 years?
3 years, irrespective of personal injury or property damage.
And 2 years for an intentional act?
That's correct.
Okay. Just something to remember. Another good feature, Washington has a lot of things going for it, but one of the things it has going for it is its comparative fault system. As I understand it, Washington is pure comparative fault?
That's right, one of the few.
You want to explain why that's to their benefit?
Well, in a pure comparative fault system, the recovery and the damages are assessed directly in alignment with the percentage of fault that's assigned. So even if there's a minimal percentage of fault, assessed to the adverse party, even if the insured is 90% at fault and the adverse party is 10% at fault, they're still on the hook for paying 10% of the damages, which is very different from what you find in other states where nobody's going to be liable for any amount of damages if they're less than 50% at fault.
Yeah, for example, Oregon, just to the south of Washington, they have modified comparative fault. And in modified comparative fault states, the damaged party cannot recover if its percentage of negligence is 50% or more in a number of 11 states and 51% or more in a number of other states. In Oregon, it's 51% bar. But in Washington, you can recover even if the plaintiff is 60% at fault. Your damages are simply reduced. And what's interesting is, let's say the plaintiff tries his case, is found to be 60% at fault, $100,000 in damages, the plaintiff recovers only $40,000. We may have a small PIP claim that we want to subrogate for, and getting back to, again, contrib, it's not really feasible for the plaintiff's attorney to claim, well, I'm not made whole simply because I had an insured or a client who was 60% at fault.
Right.
So that's something that, actually, that's part of the good news in Washington. Made whole isn't good anywhere, and we could spend another hour on the fundamentals behind the made whole doctrine, why it shouldn't apply to contractual subrogation, which is what PIP is, because your auto policy specifically states that you have the right to recover from others. And when a state comes in and says, well, we're not going to honor that contract under certain conditions, you can argue it violates the 10th Amendment of the U.S. Constitution and provisions of the Washington Constitution, but the way it is, the Washington Supreme Court has indicated that Thiringer is the law, and I think we've talked pretty much about many of the circumstances that surround it. Now, as you can see, Washington subrogation has, and we've just spent an hour on one state. We could now spend an hour on Oregon and another hour on California and another hour, actually 2 hours on Michigan and New York and some of the no-fault state where things get a little complicated. But it's just a testimony to the fact that as a subrogation professional, you have to be on your toes. You have to be armed with the law, because if you're not, the lawyer who's trying to, and is no friend of yours and is trying to destroy your subrogation rights, will surely misrepresent, and often does misrepresent, the law, or perhaps he doesn't understand it either. For example, the allegation that that the plaintiff is not made whole because they had to settle for less than their full damages. Well, it's simply because he says it doesn't mean it's so. Simply because he says the case is worth $250,000, even though you've only paid out $12,000 in medical, doesn't make it so. But we've enjoyed having you. My thanks to Eric Vershbo for, he actually traveled all the way to Wisconsin to help us put on this seminar today, and we're going to take him out to lunch as a result. We appreciate your attendance. If you have any questions, we'll be happy to answer those. You can submit those to us via the website. If there's any that we can't answer here and Eric isn't around any longer, we'll send them on to Eric and we'll have him answer those for you. So, Eric, thank you very much.
Thank you, Gary. Thanks a lot for having me here.
Take care.